And to discuss this, we're going to have this very interesting panel led by Rajesh and Venkata, Raghavan, Hossam, and Faneva are, joining them already here. And without further ado, let's jump right into it. And as you know, this is the last session, so hope you guys have the stamina for it. Thank you. Says a lot about this session.
Exactly, I was going to say that. No, this is one full house session, at least from this side. I don't see many tables are empty now, so I know the last session is always the difficult one. I see a lot of tired faces. So am I, sitting here since morning. But every session, I should congratulate every speaker and every panel here. It's been fantastic and engaging. Good evening. My name is Rajesh Ramanathan. I'll just introduce myself before I put the others on the mic. I run a firm called Factum Law. I come from one of the southernmost metropolitan cities in India. It's called Chennai. And litigation, I have to confess, I'm addicted to two things in life. First is coffee, coming from South India. And the second thing is litigation. If I don't step into court hall for 2 days, I feel like I'm missing something. And litigation has been such a overwhelming presence in my life. It's difficult to put litigation in one frame. Therefore, I don't think when we discuss for the first time what we are going to discuss here, it said, we're not going to have any presentation. One, it's the last session. Two, it's very difficult to put litigation in one frame. We have more questions than answers. So I would request you to join me, make it more interacting, make it light, make it entertaining, being the last session of the day, because I don't want you guys to leave feeling low. So let's pep up and let's have some fun. I have a fantastic brothers here, and I don't know how many of you agree with me, but for the first time, I'm meeting somebody from Madagascar in flesh. I've only seen lions and animated movies, and I haven't met anybody from Madagascar. So my friend here is from Madagascar. Why don't you introduce Faneva?
Hello, everybody. So I'm Faneva Rakotomanana from the firm Cabinet Rakotomanana, our firm. As you said, I come from Madagascar. We are the big country, the big island near Africa, and in Madagascar, we don't sing alike to move it, like in the movie. Okay, so we're talking about the litigation, but in Madagascar, we are. Okay. So I let the over to present themselves. I will continue later.
It's okay. Okay. I'm Hossam Zakaria, one of the board of HZ Legal Consultations, one of the companies which is rebooted in UAE. And we already registered at the trademark, by the way, by the same name in US also and here. And we are going to talk about let's say, the controversies of IB. Maybe my session will be a little opposite side to if IB should be exist or continuous or not. That's all.
Good evening, everyone. My name is Venkata Raghavan. So I practice out of Bangalore, and I have been in this profession for more than close to 15 years now. So we handle both IP litigation as well as prosecution as well.
I just want to share this small anecdote. When in my early part of my career, when I started litigation, I started with criminal enforcement from Bangalore. I was part of a firm working against anti-piracy operations, and we were representing the Motion Picture Association of America. So as part of my job, I have to travel around the south of India. And India is a huge country. And like somebody shared in the previous session, that cinema is big in India. So There's this particular jurisdiction in south of India, in Karnataka, the state Venkat comes from, in Bangalore, where they used to have this something called as video parlors, where they used to have the studio apartments. They will have this screen and they will screen all the latest movies even before it got released in theaters. There's a lot of complaints coming from that particular jurisdiction from the theater owners who were screening genuine movies. So I was asked to go. So I went there and I went and met the head of police, the superintendent of police of that particular district, and said, see, there are a lot of complaints coming from, because of piracy, video parlors. That particular town has a lot of colleges and a lot of young children. So they were just selling it for hardly $1 or $2 a ticket. And they were selling snacks and everything, so they were completely illegal. So when I met the police officer, he showed me a newspaper article. And they said, Mr. Ramanathan, this is what, that was an interview with one of the pirates. This goes like this. The first question was, don't you think you are violating somebody else's copyright? Don't you think it is illegal? I met the journalist later. But this pirater was hit back. He said, do you know what copyright means? The journalist was taken aback and said, I think I do, but why don't you tell me? This man says, copyright means a right to copy. I can copy whatever I want, nobody can question me. This was almost 20 years ago. And the problem for me was the police said, see, if this is what your law says, what can I do? I had to spend the next 45 minutes explaining to the police officer what is not a copyright and what is copyright. So the awareness about the IP rights then, I think we have come way ahead now, where even the general population is aware of copyright and everything, but this is where it started. People did not know what it was. Even now, if you look at the newspaper articles, they're always confused with copyright, patents, and trademarks. So, but what is challenging now is, in fact, I want to just read out a paragraph of a recent judgment, very interesting paragraph, where from Delhi High Court, a judge by name Justice Manmohan in a case on standard essential patents. Very profound statement, observation. Law always lags behind technology. Rapid developments in technology have posed unprecedented challenges to IP laws. Sans a uniform international law, courts all over the world have been applying national law, national policies, as well as international standards and foreign judgments to the extent that they are not contrary to the national laws and are suited to national reality, to achieve harmonization of basic principles of law. This is his observation in upholding a standard essential patents of Edison. This is a very profound statement. Just this two sentences kind of made me think. One, law always lags behind technology. It throws up humongous challenges, and it's now good to be an IP litigator now. Two, how do we resolve this? By harmonizing the basic concepts of law across jurisdiction. But is it possible? Intellectual property being territorial in nature, can we achieve the harmonization? So the basic pretext of our discussion is going to be that, because litigation throws up a lot of challenges. Now that, I don't know how many of you read the news today, two news items attracted me or came to my attention since yesterday. One, of course, about AI and ChatGPT. Costa Rica is introducing a bill to regulate AI, and they've asked ChatGPT to do that. A legislation is drafted by ChatGPT, and there are a lot of questions about it. Two, multiple litigation against ChatGPT. In fact, one by the famous comedian in US, Sarah Silverman, accusing ChatGPT of plagiarism. Right? So copyright and trademark, if you look at the spate of litigation in the past few years, and mostly in the United States, it throws up humongous challenges. And we as IP litigators, as IP lawyers, whoever is litigating, it's good to be a litigator nowadays because it's evolving. So I would say there are more questions than answers when it comes to litigation. So if we were able to throw these questions, when you prepare for the exams, I think you're asked, I don't know if you all did the same thing. You're asked to spend the first 5 minutes to spot the issues and then address those issues. So this session is basically spotting the issues. There are so many issues, there's so many strategies that keeps evolving. There is no set rules and regulation. But before we do delve into it, because my friend is there, and I don't know how many of you are aware of the IP field in Madagascar and the litigation in Madagascar, so I'm requesting him to start with introducing the jurisdiction and telling us what is happening in Madagascar as far as IP field is concerned.
Okay, thanks. So the IP is very young in my country, in Madagascar, because, for example, the law was created on 1989, and the register office was created on 1994. So it's very young. 1994 was also the year of creation of our firm. And currently, for statistic, we have about 45,000 filing of application and about 40,000 registration. It is about 80% for trademarks, 10% for design, 5% for patent, and 5% for commercial name. And so my presentation will be focused on trademark because of 80%. The main particularity of our jurisdiction in Madagascar in about IP is that there is no position in our country. That means when you file an application, there is no position. The publication is not immediately. It will comes in 2 or 3 years later after the filing. So the trademark will be filed and you can have the certificate in about 7 or 8 months because you must wait the 6 months of the priority. And the register office decision is a final decision. So only a judge can cancel or modify this decision. So, as I told you, there is no opposition. So once a trademark is filed, if you need or want to make an opposition, it must be done before the court because only the judge can modify this decision. So it really happened in Madagascar that a trademark is filed by the distributor or a well-known trademark is filed by a third party. So it is highly recommended to file an application in Madagascar first. Do not try to test the market because it really happens that the owner of a trademark wants to test the market, but the distributor already filed the trademark immediately. So one of their strategies is to file the trademark and to negotiate with the owner of a trademark to be the only distributor or the exclusive distributor. And it's a strategy. So the cost of filing a trademark is not expensive, but in going before the court, it's very expensive and it is very protracted because it can be more than 2 years. So anybody wants to go before the court, so everybody wants to negotiate it directly and immediately. And one of the problems also is that with the young, as the IP law was very young, there is a lack of knowledge of IP, even for the judge or the overactor. It already happened to us that we contest the decision of a register office. So we go before the court, and the judge doesn't know what is the IP. So the judge said, oh, this matter is about IP. Who is the specialist of the IP in Madagascar? So they go to the register office. So they ask the advice of the register office, even if the opposite side is the register office. So of course we lost the case. So now there is a lot of tuitions, a lot of conference, and a lot of exchange with all the actors of IP, with the university, with the judge, with the lawyer, and also with the private sector, in aim to promote the innovation and to promote the IP. So maybe I will let the over to to continue. Thanks.
So, in comparison to Madagascar, in India, what happens is it's first to use vis-a-vis first to register. So, if there is a situation wherein there is a suit, and even though the trademark has been registered by the plaintiff, but if the defendant, for example, it's the other way around, which I'm just explaining here, if the defendant is the first one to use it, still he's the one who's going to win the case. And also just to give overview of the ecosystem of the prosecution in India. So the trademarks office in comparison is quite fast. So once you file a trademark in India today, I mean, previously it was paper filing, now it's all e-filing. And then there have been situations wherein the trademarks have gotten examined as fast as even 2 days for me, 3 days for me. And generally it's around 2 weeks to a month when it gets examined. And if all goes well, if it's completely smooth, then within a period of 9 months to even a year, we have trademarks registered. Again, when it comes to copyrights, it's quite smooth again. We don't have any trouble there. You just file it, you get the diary number, you get an acknowledgement. Unless and until there's any serious objections, then again, it goes towards registration. The designs is where we feel there is an issue with the required staff to examine the designs and go through with the registration process. We don't have enough number of people to actually carry out the designs, due to which there is a huge backlog even today, and there's a lot of delay when it comes to designs. I think so. Trademarks, copyright, designs, and patents. Again, patents is quite fast as well in India. When it comes to startups, we've had a situation wherein even if all goes well without any objections or oppositions, the patents have gotten registered within a period of 1 year. So that's the ecosystem overview of India for you.
The same question was I was having for our colleague was in the previous sessions, is who decide until which level you should dispose or disclose about the pattern level, especially for example in AI, who decide which programming or which coding until which level you should show the pattern. This is one of the conflicts which we're having now in AI. How you can converse and how can you give a data until without showing the core business of your innovations, you know. Anyway, the point of I think everyone knows about that the monkey who had his selfie in 2011 by some British photographer named David Slater, and after that he used it in his publishing book. And some association came after that trying to protect his IP, saying that the IP should be for that monkey only with his rights, you know. And the presidents of LA in America at that time shows or assure that copyright or IP should be only for humanity, which creating us a decision on the conflict of AI now. You know, the big side of the IP usually is strange. That's why we're thinking of talk about different side of IP. It should be continuous as it is. Is it related to AI or some new law should increase in the AI now? You know, since 20 years, the insulin is a medicine, life-saving medicine, right? Because of the AI, only 3 companies in the world control 90% of the productions. Lilly, Snafi, and Nova, I think. And it's increasing in the country which producing the insulin in America, 17% every year, while the production of one bottle is $10. Now it's sold by more than $1,000. That is because of the AI. They are fighting against anyone trying to introduce or use the same production. Into 2020, in the COVID times, India, South Africans, and Asia went to WTO, World Trade Organization, to ask them to release the AI of the vaccinations and the treatments of things. 600 days talk until they release only the vaccination of the AI, only the IP of the vaccination. They didn't accept to release any treatments or any trial how to test the vaccine or the COVID-19. How many people died in 600 days because of the IP? Because named of intellectual property or of protection of your rights, or and if it being used like that, so it should be continuous in that. Now the technology of IP is conflicting against the AI technology. The AI should be as we said now, as my colleague said, the technology knows no board while they are moving so intelligent and so fast. If that in the other side, the legal is moving so boring, so slow. And when they decide to take a step forward, until which, how many steps the IT or AI will be taking already moving forward? And part of the discussion.
Well, it's interesting when you look at all these litigation arising out of AI and ChatGPTs and NFTs. The first issue that arises is the ownership. Who owns it, right? The first question is, if you just go on Google about the recent spate of litigation as far as NFTs are concerned. 2021 or 22, there was a litigation by Nike against one of the shoe resellers. I think it's called StockX. What the defendants did there was they kind of produced an NFT of one of the shoes, of Nike shoes. And when sued on trademark infringement, the defense, very interesting defense they took. They went into the exception of first doctrine, sale of first sale, exhaustion rights, so to speak. That I'm only saving the space for those people who invest in the NFTs, and whenever they redeem it, I'll ship them the original shoes, and they'll take possession of the shoes. So I'm not infringing any IP. It's only in the principle of first sale, exhaustion rights. I'm only excising that right. But again, Nike came back with a fantastic argument saying that, see, if that is true, these defendants, the people can never redeem or take actual possession of the shoe. They can just sell the NFTs, right? And if you look at copyright, one of the interesting cases that I think, recent spate of probably in the past 1 year or so, is when Miramax, one of the famous film production companies, sued Quentin Tarantino. Because Quentin made an NFT of the screenplay of his own movie, Pulp Fiction. And Miramax claimed copyright infringement, and he beautifully argued that no, NFTs are the derivative work of my own screenplay, right? I am entitled to it. There is no copyright for them because I own the copyright in the screenplay, and these are NFTs. And again, mind you, the Pulp Fiction was a movie which came in 1990s, I think. 1990s, before the advent of NFTs. So now, it all depends on how it is going to be interpreted. The agreement between the contract between Quentin Tarantino and Miramax is going to be interpreted, and more particularly the words, the other rights, even in the agreement, are going to be interpreted. So these throws in different challenges. I mean, it's good to be an IP lawyer now, IP litigator now, because we keep evolving with these things. Hossam, you want to comment on that?
In a couple of months ago, there was one case from in Australia, I believe, yeah. It's a defamation case against someone who was asking the ChatGPTs about one of the governors there, and the sources or else the data of the programmer of the ChatGPT was giving a defamation against that governor and insulting him. So that case still was going on with a confusion from the judge. He didn't know exactly what he have to, for whom the judge have to be against, and whether against the programmer who entered the data or because of the user just ask an IT and technology, especially you know, each IP is belonging only to humanity as per the President of US and LA, and mostly in all the laws is belong only to humanity up to now. So this is a big defect. And when we talk about if we try to implement the criminal law, you know, criminal law are so specific. It has to be following as per the act of the word, even not the meaning, the behind the meaning. So there is nothing as per that is mentioning in the litigations. So either AI is belonging to the IP itself, or it should be having a different law. One of the ideas which being created is, you know, the FDA, when they are the responsible about approving of the chemicals issue for the medications and thing in the world. Because they are a specialist in their field, they are the one who approve or disapprove for any drug dealing or life-saving drugs or something like that. Similar like FedEx role, for example, for them, when they are using any rules which belong to construction and contracting, they are the Society Federal International Engineering Association, which they issue it when they didn't follow as a guidance, not as a law, with the court. So I believe that AI needs someone who's a deep specialist of understanding of the programmings and how to work with the ITs, because in the end, as we all sit here, mostly, if I'm not mistaken, we are not that IT technologies specialist. And everything we always, as per our court, we always refer to the expert if there is something which we don't know.
Any interesting case studies in your jurisdiction?
There is one is little now, is not that much big, but there is a one singer, he's so famous. I believe most of the people knows him if I name his name. He had a fight with a tuner and composer of the songs. So what happened, as per, we all knows that story, that the composer make tunes and songs, and he used his sound from a shared or AI technology, exactly similarity of his sound, and he disposed the song by his sound and by his voice in on the market. The people was confused if he's the one who's singing or not, and he saw rebooted one of the biggest here. So now in the front of the court, it's still AI. There is nothing in the law in this country, especially in the Middle Eastern countries. There is nothing in the law speaking about AI. So how can I blame him, or how can I compensate you? Because in the end, he said, yes, I did it, but it was an AI. It's a technology, which is, you just mention the sound of the singer which you needed, it will come. So if it's illegal, why you published? How you protect that?
Yeah, that is a challenge, you know, that is how it evolves, that is how law evolves. And like I said, technology leads, laws always behind. So law has to evolve, and we have to interpret the existing laws to kind of circumvent a lot of issues. From any other jurisdiction people, do you have any other comment? Because there's such a wide area. Anybody else has any experience from other jurisdictions? So we can talk about India, we have UAE here. Okay. The next issue that we always coming from India, one of the main strategy that I find an issue is with the jurisdiction, right? Because some jurisdictions are pro-plaintiff and some are pro-defendant, right? And when it comes to, say for example, we're talking about AIs and FTs, and the infringer would be sitting somewhere else, and the IP owner sitting somewhere else. So is jurisdiction a challenge? In UAE, for example, where would you sue? If at all you want to sue the defendant, would you have a challenge in deciding, let me put it this way. There is this principle called forum convenience, right? Is that a challenge, or is that something which is recognized in this jurisdiction?
Of course, in UAE and all other countries, because we have other different branches in different Arab countries. You are trying to convey the default which happened by the defendant in a way which is as per the applicable law up to date, but it's not actually truly as per the defendant lawyers. It can be defeated easily, because whatever you are trying to build the principle on as per the existing law, it will not help you. Because anyway, the reason of IP is to innovate, to create, to motivate you to make creations and new things in the market. But on the other hand, the vague side of IP is always is to be used against you and not to be followed for the innovation of which is running much fast. So who will be in the middle? Even the judges don't, they still, we know the judges mostly having 30, 20 years of experience. How they will find out the ways how to handle that thing? How you can create it? It's like, especially when you're still mentioning that IIB is also belong to humans, not to any machines, not to any animals, not to, up to now. So this is a biggest program which will destroy any case to open. Similar like the monkey who took a selfie. Yeah.
Well, in comparison, in India, what happens is if you have a registration and if you are suing, so you can sue in the place in which you have business. So you can choose the jurisdiction. So that's the advantage what you have. Now, in case if you don't have a registration, then you can still, under CPC, you can perhaps claim Section 20, and where if a part of the cause of action arose in the jurisdiction where you're staying or where you have business, then in those situations you can file it there. So that's how the jurisdiction is decided in India. CPC is, yeah.
Any challenges in Madagascar, Faneva?
Yeah, we were talking about the IA previously. One case in Madagascar was with the photograph. They tried to use the IA, and it generates a beautiful photo of a woman. And this photo was used by someone who make the publicity or advertising. And after that, it was used also by other people. And then there was litigation about who won this photo. And at the last time, it was used also by the mayor. So at the end, everybody doesn't know who wants this photo. And even currently, they don't know who wants this photo because that is the problem. And there is another one also because the one who created the prompt, they said he's the owner of the photo. But the other one said, I use another prompt, but it generates similar photo. So at this moment, anybody know who wants this photo?
So ownership is still an issue.
I don't know what is the issue. I'll let him.
Okay.
As you said, it should be for humans, but who creates the prompt and even the ChatGPT also or the other how to say that like the ChatGPT, there is also the other one. They said we want this photo, so I don't know what the issue. Honestly.
I think also the WIPO had published a paper, this was in 2019, right? So when it comes to AI-based inventions, one of the main issue was, should there be any person taking accountability or actually stating that he or she is the owner of that AI? Because if no person or entity is actually owning that AI-based invention, then who are you going to sue? And it's going to be a complete chaos. So in my view, I feel that it is very, very important that an AI is actually held by someone. Otherwise, it's going to be completely chaotic.
Okay, the question will be here, if I own the AI and I establish it and publish it with the legal ways, and it been misused by someone else, why I should be sued? Right?
I hope it will not be misused by anyone. If it's misused, can I get a more specific example? Like what is the AI and how will it be misused?
Now, as per
Something which is not theirs, generally, I don't know how it can be misused.
Same case, I'll explain it. Same that singer, Eastern singer, which I spoke about. It is about some AI programming, which is for entertainment. You give a sound, the name of the singer, he will use the tunes of that singer. So someone use it's just for entertainment, for joking, Someone use it, establish a whole song because of that thing, and he publish it because he have the money. As usual, they are saying the rich people always win in the end.
I would say whoever is the affected party, join hands with him, claim damages, because it actually belongs to you. So you're saying if it is being misused, say it's affecting another third person or a third entity, right? Person or entity. So it's that entity or person who's going to be suing this person. But actually, this belongs to you, is what you're saying. Am I right? So you can join hands with that third person or entity, implead yourself, and then have the advantage of claiming damages.
The invention of the boom and of the bombing and the invention of the dynamite. It wasn't invited to use as we are using it now. So that means we have to kill him. No, that's the same. Misusing of the inventions or misusing of the IP is not mean, or the AI is not mean that the sorcerer or the programmer have to be involved, as per my view, up to now, you know.
Absolutely, but you have to enforce your IP as well, right? Because you're the owner. You can't let it be
And
misused.
this is another
So-
movies and another scenarios which I know. For example, I know a couple of huge companies like Apple and like Microsoft and things like that. They are usually thousands of vague IP. Usually they are using it and registering it every year. Why? Because if there is one sole inventor or someone who's independent trying to use a pattern for new inventions, and they try to find out the similarity of this before it's come up in the market with their invention, which they recorded and they registered with the millions of dollars, just to sue him and put him in the million cases with a long side, just not to get him the chances to move on with the same pattern in which they have a similarity. It's not the same, but it's a similarity on, and he will lose because he's a bull guy. So enforcing also is another story.
Yeah, you can run, you can't hide. So eventually you're caught.
It's
Well, good for IP lawyers, isn't it? See, the other thing which came to my mind was when, like Venkat said, India is first to use, and there are jurisdictions first to register. In jurisdictions where it is first to use, you will find IP owners who have not registered their IP. Let's say, for example, there are unregistered trademark proprietors, unregistered copyright proprietors. Of course, copyright registration is not mandatory most globally, but trademarks, for example. How does unregistered proprietors, are they protected? Do they have a protection in UAE, for example?
you answer because it could be the similarity in India.
You don't need registration, you just can protect without it.
You cannot.
You cannot.
See, to go to the court, first of all, you have to enforce. Nothing will be listened to
So
if there is no enforce.
So it's just first to registration and no registration, you don't have a right.
Of course, no one
Okay.
will listen to it. Even if you've been rebooted and famous by that name and that landmark or trademark or nothing. If you didn't follow the first step, it's close your shop.
We have something different here. Would you like to?
So in India, what happens is you still have a case for passing off, wherein you can still file a suit and even claim for damages. But vis-a-vis, what happens is we actually advise all companies to have registration, because what happens is infringement gives you a more wider approach. For example, say if you have a particular trademark for, like, say, ABC brand name, and if this company is using it and your mark is registered, your brand ABC is registered, and if they're using a deceptively similar brand name for a completely unconnected goods or service for which you are registered, a registration gives you the advantage to even file a case against that particular impugned trademark, even though the goods and services are completely unrelated to yours for which you have registered. So that's why registration is very important. But even otherwise, if you're unregistered, but if you're first to use, like I earlier mentioned, you can still file a case only for passing off and still claim damages as well.
What is your position in Madagascar?
In Madagascar, as I told you, it is highly recommended to file because it's like in the internet, first file, first serve. But for the well-knownest trademark, we have the protection. We can use the Article 6 piece of Paris Convention, but the well-knownest will really depend on the judge. Because, for example, here when we're talking about Starbucks, McDonald's, or Burger King, everybody knows what is it. But in Madagascar, it's not really well known. Anybody knows about what is Starbucks? So if you file Starbucks trademark, judge can consider it not a well known. So it will be case by the judge. And the other solution is that to use the copyright, for example, mainly for the logo. You can use the copyright for. It's not really copyright because we are like a French droit d'auteur. Yeah. So you can use it to cancel or to have back your trademark.
And when it comes to litigation, the most important, at least coming from India, the first question is the time factor. People complain that it takes too long to litigate in India, right? I think most of us from India would agree that it does take time. But how long does it take? What is the time factor when it comes to litigation in the UAE, Hossam?
Not more
From
than
start to
2
finish?
years. Not more than 2 years.
Not more than 2 years. That is
With
fantastic.
all the 3 levels.
Yeah?
Yeah. Yeah. There is of course, there is a special private case situations, but not more than 2 years in UAE to be patient, mostly. And if you win it mostly, 60, 70, 80% of your cases, if you win it in the first hearing instance, then mostly you will be winning, except if there is a big mistake. But it wouldn't take too much. Even the registration here is not that much longer, especially the patent issue, because patent take 2 to 3 years, as I heard, but by little lesser, but it's moving more faster. And don't forget about, we are still a new Genian company or a new Genian country, which is 40, 50 years only. So not all the Supreme's precedence has been applicable is still in UAE, and they are not facing everything which countries like India or Egypt or who was so ancient in the laws, similar to that precedent which you have there, similar to that case, yeah. And one last scenario I would like to share it with you after I had a discussion with Dr. Muhammad, who found out is an expert also in IT, but he's not here anyway. We were discussing about the same, about AI and the IP and the protection and relation between them, if they are related, not to protect of the technology or not. He was mentioning about one case of a company which was trying to fund the money of $10 million, a board of that, to some company in UAE, and after the money being transferred and get exit from the country, it's shown it being transferred to the country in UAE, and the country in UAE give a proof that the money didn't reach to them by cryptocurrencies, by the way. And Mr. Muhammad was working on it with his teams, and he found out that the mistaken or the default or the dark side is when you are offline in the cryptocurrencies to change, there is a code which will be known only by the owner of the company. And that code should be when you are offline and you are starting to be online to transfer, that code should be initiated. They found out the company that the cryptocurrencies company in that time, there was giving us hotspot line online people who's transferring the money, like what Snapchat, when you are looking for people, there you find the who's inside there. So that was the biggest gap which being used by some hacker, and they spotlight the money when it's being transferred exactly in the same time, and they know where is the sources, they transfer it to them exactly. So that's part of the technology which is still up to now, the legalism is not covering it and how to protect it. Especially, it should be as, let's say, the various flows and the border between each countries kept everyone looking to his board only, not out of board.
Interesting. Would you like to take over as far as India is concerned?
Well, what basically I advise is press for ex parte injunctions, interim reliefs, because sometimes it so happens is, especially in Karnataka, like in India, every state has its own specific rules as well. Like in Delhi and Madras, we have a special IPD bench today. In comparison to a Karnataka, what happens, the state in which I am practicing, is we try to stress on ex parte injunctions, trying to stop them from using, for example, if it's a brand name. And then later on, it depends also on the party, right? If the party is, if the opposite side is small, if it's maybe even medium size or large, if they're willing to settle, then generally it just pretty much ends there. Otherwise, the entire civil procedure code which we follow, the system is quite, the kind of written statement from evidence filing to the arguments. The entire procedure is quite big, and it can get dragged on for years. So in our situation, in especially in Karnataka where I'm practicing, I stress on trying to obtain interim reliefs so that you force the opposite side to come forward for settlement rather than dragging on the case. Yeah, I can hear you.
But no one in the others can hear you.
Your mic is, yeah.
in India, how many times does a case go for settlement rather than to the court?
It all depends on the defendant. If the defendant is notorious, then it can get dragged on for a long time. It so happens that most of the times, in my experience, defendant is notorious. So he's a step ahead and he knows all the loopholes, and the person is well aware of what they're doing. And in fact, they're just waiting for the case to, be filed and maybe receive a summons. But maybe I would say 10 to maybe maximum 15% of the time, it so happens that just by sending a cease and desist notice, not even filing a case and obtaining an ex parte injunction, you just send a cease and desist notice, sorry, they just call you and they're all intimidated, they're scared, they're like, I'm sorry, it just genuinely happened, and it stops right there. It so happens that sometimes when the damage is very bad, we just straight away go ahead, file the suit. Unlike a Bombay, where you send a notice of motion, that is a summons is first issued, and then the opposite side can come forward and actually produce their case. In Karnataka, what happens is straight I can go to the court, obtain an ex parte injunction. The injunction order straight goes to the person who's been using the trademark, for example. So that time again they're quite intimidated, like, whoa, I've got a court notice, right? So they're very scared. So then again they've come forward and they've actually settled the suit. So this has been my experience actually. I would think so. It's only reducing with time.
See, because India was so notorious for the delay in litigation, I think the government came up with a new legislation in 2015, others from India would also know, as Commercial Courts Act. The Commercial Courts Act stipulates a time for each and every step. And one other thing the Commercial Courts Act did was making pre-suit mediation mandatory, right? So IP disputes are defined as a commercial dispute. So mandatorily, you will have to mediate through the mediation centers in each and every jurisdiction before filing a suit. But of course, that is an exemption where the suit contemplates urgent interim relief, right? And again, different jurisdictions hold it different ways. Delhi High Court holds, just filing an interim application would contemplate urgent interim relief. But Madras High Court, there are a couple of judgments which says no, the court has to rule if it actually contemplates interim relief or not. So that debate is still on, because being a common law country, each and every jurisdiction holds it in one way or the other. But what this act has done, it has made mediation mandatory, but mediation by definition is voluntary. But for the first time, legislation has come up where pre-suit mediation has been made mandatory, which has been upheld by Supreme Court as well recently, in last year. So invariably, you first approach to settle. And only if those cases which doesn't settle, they go to court. Right?
And yeah, there is as per one studies which I was reading before. I think Germany and one of the Europe countries, and thank you for that question, by the way, are forcing to go to mediation only. Only. You cannot go to the court. This level. Yeah, only mediation, and they're solving it in 3 to 6 months maximum for IP, any conflict of IPs attacking or interrupting or something like that, which is good for them to be filing, because they're giving a binding order within that much only time. In the other countries, they are giving only arbitrations as a mediation level, but it's going to arbitration because it's more, let's say, more specified in not in legalism as more of technology and progressism. So they are looking for that side also. But most of the countries or most of the legalism or systems, as per Mr. Rakesh was asking, its mediation is coming as a starting of initiating any cases in most of the other countries.
See, generally, we are hardcore litigants, right? Litigation is mostly because of our personal egos, right? My grandfather was a lawyer, so he would, in a small jurisdiction outside of Chennai, and he used to say, for a branch falling into somebody else's land, you would spend more than the cost of the land, right? So it's mostly the ego that is involved here, and egos don't settle. And most of the lawyers in litigation, they survive on litigants' egos, right? I can't complain, but that keeps me going on for a while, but that is what it is. But because of these things, obtaining an interim relief assumes significant importance, at least in common law countries. Why don't you share the kind of interim relief that we can obtain in our country?
So in India, like any other country, first you have the injunction, or more commonly known as a restraining order, stopping the other side from using any of your IP. That's one of the first interim reliefs what you can obtain. Then you have the standard ant and pillar orders as well. So where in India, again in Karnataka where I'm practicing, so you have a local commissioner who you appoint, and then you go, and then either it's a civil or a criminal seizure of goods, and then those goods are then produced before the court. Then you have the Mariva injunction. So here what happens is you freeze the assets, the IP assets. So that's another interim relief which we can obtain. Then we have the John Doe order, or in India it's more famously known as the Ashok Kumar order. So where when you don't know the defendant, you obtain this order. This is another kind of relief which you can obtain here. Then very interestingly, you have what is known as anti-suit injunctions, which are obtained by Indian courts. Now in anti-suit, what happens is generally when there are two parties, you file a case, you get the injunction, the defendant is restrained from filing on the same subject matter in any other country, which is the subject matter of the suit. So he's restrained from filing in any other country. So that's another injunction, another interim relief which you can obtain. Then you have the dynamic injunction. Again, I think this was in 2019 when the Delhi High Court first issued the very first dynamic injunction. Now, dynamic injunctions generally are obtained against websites, wherein, for example, once you have showcased and proved that you're the IP owner and you have successfully obtained an injunction, say against, for example, YouTube from taking down a particular link. Now, if there's another link which has popped up, you don't have to go through the entire drill of actually showing that you're the IP owner. So all in Delhi you have to, and this is available only in Delhi. This provision unfortunately is not available in any other states in India. So you can just go to the joint registrar and just extend the injunction what is already received on the same defendant on the other link as well. So that's all you need to do. So that reduces your entire burden of going through the entire process all over again. So these are some of the interim reliefs what you can obtain in India.
As a corollary to that, a lot of brands of international repute have lost their protection, at least in India. I'm following up with a question on that. Because they are unable to establish that they have reputation of international standards. The case in point will be Toyota Prius. Prius couldn't protect its trademark because the defendant in Delhi was using Prius as a trademark for its car accessories. And court said, sorry, you claim to have adopted and established Prius in 1990s, but you're not available in India. And you haven't filed any documents to show that your people in India know about your reputation. So they've lost it. So, trans-border reputation, transnational reputation, how much of it is recognized in your jurisdiction? That becomes because most of the brands of international repute, they may not have be physically present in one jurisdiction, and it becomes easier for all the counterfeiters to infringe and use the names. What happens in UAE? Is it recognized? Is that a trans-border reputation or transnational reputation is recognized? No? Okay.
Because I never heard it before.
That's why it's good to be a lawyer in India.
Just to add to what Rajesh mentioned about the Prius case, so here it so happened that the Supreme Court, first it was a case which was filed in the Delhi High Court, The Toyota company won in the Delhi High Court. Then the defendant appealed before the division bench, and which overturned the decision and went in favor of the Indian company, which was actually using Prius brand name. And then eventually the Japanese company again appealed it before the Supreme Court, which held that in India you have to show what is known as a spillover effect to show a trans-border reputation. For example, say hypothetically you can be Ferrari, right? I mean, Ferrari is there in India. Hypothetically, let's just accept for a moment that Ferrari is not there in India. And if Ferrari has to enforce its brand name in India, it has to show what is a spillover effect. Now, the Supreme Court has also laid down various factors on how the spillover effect can actually be established. You have people, for example, just us, right? All of us have traveled from different countries and we have come to Dubai. So you read magazines, and of course today we have internet. So you have various these kind of mediums through which I have gotten to know Ferrari and I know the brand exists. So if you are able to show, so what the Supreme Court in India has held in this prior cases, if you are able to showcase a spillover effect, then even though, and like I've previously also mentioned, in India it is first to use, not first to register the brand name. So if you're able to show a spillover effect, even though the latter person from India or any other country in India has registered the trademark, due to the spillover effect, you can still claim your brand name. So that's the position in India.
So what do you think is essential when, say, for example, an international brand of repute wants to stop somebody in India? What evidence that you think that the company should produce, strategize even before they sue?
I would say a lot of, maybe perhaps it depends, right? I mean, if you're into, say, fashion, for example, or even into automobiles, Ferrari, if you could actually show the website, any kind of maybe perhaps even magazines which has been published for the Indian, people, or if there's any other way at all, anything to do with the internet, anything to do with electronic mediums, where you could establish that Indians are aware of this brand name, that could also establish spillover effect. And that's how, and of course you will have to first show that you have perhaps not only filed in your own jurisdiction, but you have also filed the trademarks in various jurisdictions. And it's very, very important to show the strength of your brand name, like how huge you are, how humongous you are, because it's only big brand names, like maybe you have maybe Maserati, you have these again BMWs, you have a Ducati, or even like Vogue when it comes to fashion, right? I mean, like Vogue today, though they don't have like a serious presence in India in comparison to a New York, but still the fact that Vogue is known, since India is known for the movie business, maybe some Vogue magazines which shows some of our actresses as well can also be produced before the court to showcase the spillover effect. So those are some of the examples which I can think of.
You said there is nothing, you haven't heard about it.
So you believe that principle of the first to be used before the first who registered is a good principle, or is a correct principle in India?
I would say yes.
Why?
I would say yes as well, because you have, for example, there are so many industries. Okay, the incense sticks. In India, there are quite a few companies into incense sticks which were started by the forefathers. So this was in the 1950s and 1940s. So in Bangalore, where I'm residing, there's a particular area where all of these incense stick companies are located. And it so happens that they don't bother about filing for the trademark because they're so big. And believe it or not, they actually export these incense sticks to Dubai, also to US and various other countries. And sometimes it so happens that, there are these, again, notorious defendants who would come and, try to file for those trademarks. And I would say that since you're the first one to use it from forefathers, right, from 1950s, you have been using the brand name and all the households know your brand name. So it's very important, like just to give this example, this industry as an example, Since I was the first to use, I should have the final claim over the trademark because, first of all, the defendants already are quite notorious. You're just giving more room for this notorious behavior by having a rule otherwise that first to register will have the final claim vis-a-vis first to use. So I would say that the rule is apt and the rule is appropriate because as a genuine user, as an honest person, first to use will have a final claim, should have a final claim, sorry, according to me, vis-a-vis first to file.
See, this also goes on to my next issue, it's the cost. Cost of filing. I mean, look at the population that India is amongst the world, it is the world's most populous country, right? IP filings, it's not cheap. And if you expect people to first acquire the registrations and then only get the right to sue, it'd be difficult for them to innovate. So at least for India, first to use works. And it feels lawyers.
That's what I was attempting to say. It's a special case for India. It cannot be as a publication for every country, but it's only for Indians because India have a different circumstances, different habit. So they used to accept that as a pass-by route or pass-way route to do the similar with your registration, because if you use it in different countries, there is a many ways how to show and allegate of you been using the trademark or the land or the name of the companies without actually having it. And there is many ways to be used, also related to artificial intelligence, AI and technology and things like that can be published easily for that part. So that's the registration was the reason of the registration, as I understand, is to protect in the end. You know, that's why in such cases here in UAE, if you didn't register, don't come here. If you don't use it, you will lose it, usually.
Right. Venkat, sorry, wow. Sorry.
Even the next room heard you.
One of the things that jumps out at me is, you know, when you say that somebody is using, there's an automatic assumption that it's a misuse, meaning your forefathers have, you know, been selling this agarbatti under a certain trade name, and then the other person who jumps in is automatically a misuse. But from anybody else's point of view, there could be inadvertent, honest use which just happens to mimic your trademark. So in those situations, I think there has to be a fair balance towards this other person who has inadvertently come up with that, right?
And that is why the first user works. So the inadvertent user who had come subsequent loses.
I see that, but what I'm trying to say is his point that the first to use is not necessarily a best, you know, use case scenario. There is a valid argument for that.
100%.
And
100%. Yeah, 100%.
It's a choice, I think, as a country, as a society, whatever we have made. You know, I'm not going to. It's right and wrong. But there is a valid argument and a hard and fast position can be argued both ways.
Absolutely. Absolutely. Right. But litigation is, you know, a law is subject to interpretation. Right? It's 99% common sense and subject to interpretation. You can argue. I mean, if you cannot argue, you don't need lawyers. Right? Yes, that's a valid argument, yes. But India as a country follows first. In fact, a prior user can even restrain a registered proprietor in India because it's first to use. Right? That begs the last question, last issue for me, the cost of litigation. Even a previous panel suggested that startups, they don't litigate because of the cost. How expensive it is to litigate in UAE? I know it's very, but...
No, actually, it's not that much costly in Dubai, at least, because in Abu Dhabi is different. Each emirate have a different procedure law for litigations. In Dubai, the maximum is for any claim litigation, it will be 6% from your claim up to 40,000. But with Abu Dhabi, there is no max cap. 6%.
When there is no claim, it's just an infringement.
Yes.
Then what is the expense? When You're not claiming any damages, so just asking to restrain the
See,
defendant.
agreed. But if you are going as per legal systems, as per the court system, or as per the arbitration, and as per the specific rules or IP lawyers which you are using it, all that is additional cost, or let's say as a collateral cost, which is more expensive than the court itself. To prove your evidence, to collect your document, to have expert lawyers to get your evidence until end, to reach the level of getting the judgment in your favor, if you can do it, which is not about the legal system itself. It's about the besides costs which you have to pay. And you don't know in the end if the compensation will cover all that or not. But in the end, the principle is to defend to get your rights. That's all.
So you're saying that it's only the lawyers who are more expensive than the cost of litigation?
Isn't it?
And would you like to comment on that?
Well, again, in India, it depends the amount of time that it takes, because what we do here is you charge per appearance or per stage, right? So if the matter gets settled, then generally the cost involved is lesser. So that's why even we advise the clients to force for any kind of interim relief, exhaust all those options before you can finally go to a long drawn suit. But otherwise, generally, it is expensive. Not that expensive, maybe perhaps in comparison to other jurisdictions. But yes, there is a cost depending on each stage, and it can go up to a couple of lakhs depending on how long the case is drawn for.
See, if it is not expensive, how do you think for us to come for these conferences, attend, and go back? It better be expensive, right? I think we are almost at the end of, that's the time we have. Any questions that any of you have? You don't want to meet us, Peter. You don't want us to come here.
One of the things I was wondering, you get your opinion on when you're advising on drafting contracts and you get to the dispute resolution clause. What are some of the things that you advise your clients or you like to see in dispute resolution clauses to try to avoid litigation?
See, personally, off late, the dispute resolutions, when you go for the alternate dispute resolution, I find those are more expensive than litigation in court. Because the arbitrators, the amount of money you pay the arbitrators, who mostly are retired High Court or Supreme Court judges, they charge more than what a regular court will cost. So off late, in all the contracts that I advise, I kind of give the option of dispute resolution, plus having the equitable reliefs, giving the right to go to the court for equitable reliefs. So that, if it is too expensive, if arbitration gets too expensive, they do have an option of going to court. So off late, I try to overstep the dispute resolution clause and just give it to, the courts. I tend to feel that arbitration is getting more expensive off late than litigation in courts. Would you like to?
Yeah, same here as well. I mean, even if there's a mediation clause, what would the mediation do even otherwise? Because if there is a dispute and if it was to be settled between the parties, you wouldn't go to mediation. So the next step is arbitration. So in India, again, arbitration sometimes can even get more expensive. The only advantage what you have in an arbitration vis-a-vis a litigation is you can choose the venue and you can choose the dates. That's about it. But otherwise, if it's drawn for a long time, the procedure is pretty much the same, because the same rules of civil procedure code, the evidence in India is applicable even to arbitration proceedings as well. So it gets over fast. I was just about to say that other than the fact that it will get over faster, but you may land up having many more number of appearances and dates in comparison to a litigation. Again, it's very subjective. I mean, you cannot pin down and exactly say this is how it will go, but this is very subjective. So this has been my experience as well, similar to Rajesh's.
To add to what he says, I have had a few arbitrators who are retired judges, fixing some exotic locations as venues. Yeah? So, so I completely think it's better to go into jurisdiction-wise and approach the court.
See, that question is so intelligent and so opening, and thank you for bringing it up, but I, let's say, little disagree about it because it's depending on the complicated of the issues and the complicated of your field in the market. If you are working, for example, in IP or AIs and some things which cost you or covering your profit with the billions and millions, it's better to go with an arbitration clause because, and it have to be specified arbitration clause, even if it costs, but it will win yours, it's better. Because litigation, regardless, it's maybe cheaper, but the experts and the specialist in the field which you will be going on, it's not existing always in the courts. And you cannot assure whoever named as an engineer, for example, he is actually as an engineer or not. We faced all that. They speak in frank, right? Not all that names are similar. So if it's depending on your complicated and how much you're trying to protect your names and how much the profit is coming from that. If it's coming and you are ready to spend, then it's better to go to the arbitration with the specifying the benefit of the arbitration is not about the faster only, it's about you can choose someone who's don't belong even to law, but someone who's a specialist in the dispute pattern which you are looking for. That's my point.
And again,
Exactly, because anyway, as you said, patent is taking 2 to 3 years only to register, and it's costing a lot of billions. Even a trademarks, it can be by normal customer conflict or normal customer eye as a evidence can be used. We had some perfume in Egypt, for example, before 20 years, it was a big case between someone, perfume named 3 fives, 555. A company came against that to make it 555, and another 55. And it's used the same exact colors, the same exact color of the material, the component, the thing, which was a famous repetitive. So this can be used in the court easily because it's, for consumer, it gets confused. And one of the similarities is the reason of creating a case for IP, right? For this, for example. But for technical deep, like pattern which you mentioned, like what we use the core details of the programming for an AI and until which level you should expose your business without expose the source of your innovation, that is will not be known by someone easy, even us. That's all.
so if you come to India, don't arbitrate. If you are in UAE, please arbitrate. That is the answer we have. Yes, please.
My question is something different. In India, we copy 50% content, including video, image, and text from other websites. So, my question is there any possibility to save small businesses from IPR lawyers?
See, the fact that you use the word copy, right, itself there, it defeats the very purpose of IP. You can't copy. You can be creative. Don't copy. You have to be innovative enough to show that it is not a copy. It is something different. Then you can be saved from us.
Okay, thank you. Great.
You know about the unified patent system in Europe, which is, I don't know. First of all, let me ask you, what's your opinion on that? And from a hippie point of view, is that something that can be translated to other parts of the world? Is it even feasible?
I have some knowledge, probably some, as far as very difficult to replicate it in all the jurisdictions. Of course, we do have unified patents. You have PCT, because see, the definition of IP is territorial in nature, right? The foundation is territorial in nature. So to have an unified patent covering different jurisdictions, I would say it's impossible. They have, they have a fundamental union there. There is a European Union. Correct, Union of States. Correct.
Similar to
Not
a trademark
other
price
jurisdictions.
But it's a
classification,
very,
right?
see, the Europe is a very loose union. You know, it's not a hard and fast union. So EU as an economic entity could have like 50 of those countries, whereas EP is only so many. And the filing and granting is allowed in, I think right now it's 42 or 43 countries. The unified patent system allows for litigation, and that's a smaller subset, where they say that if there is a litigation in one country and there is a judgment, then it is, you know, you can go and enforce it in these are the countries, which is, I think about 12 or 13 as of now, something like that. It's a smaller subset. So it's not across EU, everybody accepts something, it's not like that. But at least it brings together a handful of countries where Netherlands says this is an infringement, then Belgium and France and Germany, they all say, fine, we bought this judgment, and vice versa.
Similar to a CTM for trademark. You have a community
Right.
trademark, right? So you file one application, CTM application. The same is valid across the EU. So something similar for the patents.
UAE, for example, or MENA, or
Is it possible to get a handful countries as a union? That's the question.
There you go. That's the answer.
That's a very good one.
I think we shouldn't hire people more than this. Thank you so much. Thank you, friends.
Thank you,
It was a very engaging session. I hope you enjoyed.